Good day and welcome. My name is Mike Branca. I'm a workforce development analyst assigned to the Bureau of Workforce Development Administration's Policy and Planning Coordination Services Unit. It's my pleasure to provide this presentation of L&I's Employment Services Complaint System Policy. Before we begin the presentation, I do need to inform you of an important notice. Pennsylvania is a two-party consent state. As required by law and adheres to Commonwealth policies, we do not consent to any recording or transcription of this meeting, including artificial intelligence recordings and notes, and including any third-party applications. Please turn off all recording devices and/or software. We appreciate you honoring this notice. A copy of this presentation with speaker notes will be made available afterwards. Thank you. So let's begin. A question may be raised as to why we're providing another presentation of the ES Complaint System Policy since we provided a presentation in 2024. The reason is because the ES Complaint System Policy needed to be revised due to USDOL revising the Foreign Labor Certification Program regulations in 2024. Importantly, the FLC regulations affect the Wagner-Peyser Act regulations, thus USDOL revised them. Happily, because the revisions were administrative in nature, L&I revised the ES Complaint System Policy and posted the updated policy on our policy website, February 24th, 2025. A major part of this presentation will include an overview of those changes. Let's begin by going over the presentation's outline. I'll explain some policy background and recent history, an overview of the revisions, and offer a high-level overview of the policy's purpose, statement scope, some key policy elements, and end by discussing how the local area board and its one-stop operator play a part in ensuring customers' complaints are properly accepted, filed, processed, and resolved. It must be stated up front, BWPO merit staff are fully trained to operationalize this very dense policy. I think it's okay not to memorize every page of policy to have a good grasp of a policy's content and what it may mean in terms of your authority and responsibilities. I will endeavor to bring forth value and meaning today. To put this discussion into a helpful context, let's first start with some background. The L&I ES Complaint System Policy was created in 2020 at the behest of USDOL. The Bureau of Workforce Partnership and Operations, or BWPO, is tasked by the State Workforce Agency to establish, maintain, and operate the ES Complaint System. BWPO worked with BWDA to create the policy as well as operational guidance. This policy is rich in regulatory language because of its historical beginnings many years ago in a courtroom that led to the establishment of the Migrant and Seasonal Farm Worker Program and the ES Complaint System. USDOL is adamant that these two major elements of the Wagner-Peyser regulations be implemented by the book, if you will, and they expect our policy to be in total alignment with all relevant regulations and guidance. If you may remember, USDOL released the Wagner-Peyser Act staffing final rules in November 2023 and were effective January 2024. L&I updated the ES Complaint System Policy with additional information surrounding some minor regulatory language revisions, state hearing officials, and discontinuance of ES services to employers. We also improved our merit staff training by creating a structured ES Complaint System training program. Just as we thought we were done with the ES Complaint System Policy, USDOL released on April 29, 2024, the Improving Protections for Workers in Temporary Agricultural Employment in the United States final rule. This is a Foreign Labor Certification Program regulation. The final rule's effective date was June 28, 2024. The Improving Protection for Workers in Temporary Agricultural Employment in the United States final rule affects Wagner-Peyser final rules 20 Code Federal Regulations, or CFR, 651 653, and 658. Much of the ES complaint system is rooted in Part 651, which is mainly terms, and Part 658, which is the discontinuance of ES services and reinstatement of those ES services. The policy needed to account for much more detailed description of these subjects as found in the new FLC regulations. L&I took advantage of this revision period by improving the overall readability and organization of the policy's subject matter as well as formatting. Let's move to the policy revision overview. The policy was revised to align with 2024 revised Wagner-Peyser Act staffing final rule and to maintain alignment with BWPO's ES complaint system operational guidance. I want to give you the wrong impression. I start describing the revisions. The revisions are either required revisions by USDOL or are stylistic revisions to improve readability. So let's get into it. Some specific revisions to the policy include: overall, the policy has been reformatted to fit the new Policy Planning Coordination Services Unit policy organizational structure requirements. Okay, updated policy statement with an expanded outline to improve readability. Pages 2 through 5, it was the definitions section. We added new key definitions of an ES complaint system and removed real common knowledge definitions, such as the definition for Java. We revised certain definitions, for example, discontinuation of services. We added a period up to 3 years that the state workforce agency can discontinue services. For the municipal farm worker, we modified the term to increase the understanding of the acronym. Farm with a contractor, we added Pennsylvania Office of Labor Law Compliance per the request of the Office of the State Monitor Advocate. Pages 5 through 6. The State Workforce Agency Distribution of Responsibility section. Some other language edits were added. We revised the state-level ES claim system representatives, item E, to increase term use consistency. We revised State Monitor Advocate to align with the ES final rules. We revised state level coordination by adding language to allow designee to act on behalf of the state level ES complaint system representative. Pages 6 through 7. ES complaint system notices posters communication requirements section. We moved English language requirement narrative into the section to improve readability. We moved confidentiality narrative into the section, also to improve readability. Page 7 through 8, the local office of centralized ES complaint system forms and lot section was strengthened by collecting and moving upwards and logs into this section. Narrative updated to align with ES rules, and we revised to account for key BWPO operational processes and edited to improve readability. Pages 8 through 10. Complaint types section was strengthened by collecting and moving all complaint types into the section. Narrative revised to align to the ES final rule, and we improved readability. Specifically, complaints about the out-of-state employment association agency narrative was aligned with the ES final rules. ES-related complaints was cited, which was 20 CR 658-400A. Complaint-related law complaints was added to reflect current ES final rules. Complaints alleged unlawful discrimination or reprisal for protected activity narrative was aligned with ES final rule and state workforce agency operations. Finally, non-ES related complaint types, such as the Office of Opportunity IDF, was updated with the language. Pages 10 through 13, Accepting, Processing, and Resolving Complaints, is a new section designed to improve organizational flow and readability. Existing policy and guidance language is moved into this section, vetted to ensure alignment with the ES final rules and BWPO operations, then lightly edited to ensure language consistency, as well as correct use of terminology and roles of BWPO staff. Pages 13 through 18, Discontinuation of ES services, found at 20 CFR 658.500. This section was greatly expanded by USDOL in the recent ES regulations. The section is highly aligned with new ES regulations. This clarification information was directed to the State Workforce Agency operational role. A note explaining this action was added to the policy for the benefit of readers. Page 18, Request for Hearings or Appeals, was aligned with the new ES regulations. Page 19, Local Workforce Development Board Requirements. It was edited to maintain language consistency. Page 19, Supporting Information section, was updated with current regulations and guidance applicable to the ES complaint system, and citations no longer applicable were removed. Page 20, the History section, was revised to reflect policy has been updated to align with current Wagner-Peyser's final rules. And finally, page 20, the Public Comment section. It was revised to account for why the policy was not posted for public comment. Let's move on to the policy overview. We've provided you with some essential general information, such as the policy's full name and the effective date. What we call the policy owner is L&I's Bureau of Workforce Partnership and Operations. A policy owner is the entity that's tasked with the responsibility to enact the policy. I'll explain shortly BWPO's key roles regarding the ES complaint system. We have provided BWPO's state-level complaint system representative contact information should you have any operational-based questions. Let's move on to the policy purpose. All our L&I policies developed within BWDA have a defined purpose section. This policy's purpose acknowledges our workforce development system serves a diverse set of customers. Consequently, a wide variety of complaints can potentially occur. Employment Service, or ES for short, regulations require a complaint system that accepts and processes customer complaints specific to Wagner-Peyser funded services and activities. The policy's purpose articulates how statute and regulations authorizes the establishment, staffing, operation, and maintenance of the Commonwealth's employment service and employment-related law complaint system, also known as the ES complaint system. Also, the purpose articulates how the ES complaint system is focused upon the acceptance, resolution, and/or referral of Wagner-Peyser Act-based complaints. The policy statement presents relevant statute, regulations, and USDOL guidance based upon policy subject. In this case, you can see the ES complaint system is tied to the Wagner-Peyser Act. The statement also is written to establish the state workforce agency's responsibility and authority to establish and maintain the ES complaint system. L&I is required to take on the responsibility of establishing and maintaining the ES complaint system. We added information indicating BWPO is the specific entity tasked by L&I with the administrative, financial, and operational responsibilities associated with the ES complaint system. It was decided to expand the statement's policy outline to improve readability. The policy scope indicates the parties the policy applies to and/or affects. As you can see, policy applies and/or affects almost all the key stakeholders found within our public workforce development system. The list of Wagner-Peyser Act funded services and activities is long and varied. Most people are familiar with the employment services provided by the state employed staff, also known as merit staff, and all the Pennsylvania career link sites across the Commonwealth. Of course, there are many other services associated with the Wagner-Peyser Act. For now, understand these universally provided services can be found within our one-stops and throughout the local area. Another important reason why so many entities are found within the policy scope is because the policy reflects the ES complaint system's referral mechanism. If complaints are not based upon the Wagner-Peyser Act and are directed to BWPO's complaint system representatives, those non-ES complaints must be referred to the appropriate entity. The referral process is explained later in the presentation. Let's talk about some key terms found in the ES regulations and WEO Title I, Section 3. That's terminology. At the heart of the ES complaint system is the actual ES-based complaint. Please take a few seconds to read the definition. In terms of the ES complaint system, the complaints are specific to Wagner-Peyser or a complaint that relates to the employment relationship between employee and employer. The regulatory definitions provided are very clear as to whom a complainant or a respondent may be. Please take a few seconds to read the definitions. The list of potential complainants is expansive. Note that an ES complaint must be filed. Also note that a respondent is alleged by the complainant. Up next are some key roles fulfilled by state personnel. Complaint System Representative, or CSRs, are found within the local area one-stops. They must be one of BWPO's merit staff. CSRs do the heavy lifting of accepting and processing the ES complaint. There's another type of CSR, the state-level CSR. That individual is a BWPO employee and is located at the Harrisburg Central Office. The state-level CSR is responsible for the efficient operation of the ES complaint system. As you can imagine, this person has many associated tasks, and these responsibilities are outlined within the policy. Employment Service Office Manager means the ES staff person in charge of ES services provided within a one-stop center. To reduce confusion, we identify ES office managers, also known as PA Career Link program supervisors, within the policy. In terms of the ES complaint system, the ES office manager is the CSR's backup and files required complaint logs. The ES complaint system can process three types of complaints. These Wagner-Peyser Act-based complaint types have different ways to be accepted and processed. The first type of complaint BWPO CSRs can accept and process involve failure to comply with Wagner-Peyser ES regulations and/or complaints against an employer about the specific job to which the applicant was referred through the ES office. The second type of complaint CSRs can accept are employment-related laws, meaning those laws that relate to the employment relationship, such as those enforced by USDOL's Wage and Hour Division, Occupational Safety and Health Administration, or by other federal, state, or local agencies. CSRs will refer those type of complaints to the appropriate enforcement agency. The third complaint that can be accepted are apparent violations. Apparent violation means a suspected violation of employment-related laws or ES regulations by an employer. which an ES staff member observes, has reason to believe, or regarding which an ES staff member receives information. Often, these types of violations are sourced from outreach staff. Okay, we've gone through the first part of the policy. Let's get into what I would call the policy proper, meaning the main body of the policy. Complaints may take the form of an expression of dissatisfaction, protest, distress, grief, or pain. The source of the issue may be potential discrimination or civil right violations, a customer being denied occupational training, potential employer practices that violate a law or regulations, program partner or service provider dissatisfaction, or a concern about the general operations of a PA Career Link service location. We've added this introduction because each local area has established a complex, overarching complaint system for their workforce development area to accept and process a wide variety of complaints. The ES complaint system is a part of that system. The ES complaint system policy speaks to these local area complaint systems at a high level, so there would not be any conflict between state and local area policies. Each local workforce development board has ensured a method exists so that a customer's complaint is accepted, filed, processed, or referred to the appropriate agency, program partner, or service provider, and resolved as efficiently as possible. An employment service-based complaint is a representation made or referred to a state or ES office of an alleged violation of the ES regulations and/or federal laws enforced by federal, state, or local agencies enforcing employment-related law. Again, it's important to remember the policy is specific to the type of complaints the ES complaint system is designed to accept and process. Only Wagner-Peyser-based complaints are accepted and processed accordingly. Complaints can be filed by any entity that encounters the public workforce development system. The ES complaint system existence must be made known in all one-stops. For example, that's why USDOL requires ETA design posters to be hung at a prominent location within the PA Career Link service site. Additionally, customers are provided a BWPO designed handout that explains the ES complaint system and how to express their complaint to a trained CSR. Finally, most ES complaints are accepted at all one-stop center locations or by BWPO's outreach staff. Occasionally, the BWPO central office accepts complaints. Let's discuss distribution of responsibilities. The CSRs are the frontline staff that accept and process complaints. ES program complaints are acknowledged in a timely manner and are properly documented, logged, and resolved as expeditiously as possible within the local area, or if required, are elevated to an appropriate Commonwealth and/or federal government agency that can resolve the complaint. CSRs may do other duties as found within the BWPO ES complaint system operational guidance, such as referring non-ES complaints that are associated with other local area programs and/or services. The ES office manager is responsible for the day-to-day management of the local ES complaint system and may designate an ES staff as the CSR. The ES office manager must ensure a complaint system representative is available during normal business hours to take complaints and explain how the ES complaint system works to the complainant. The ES office manager is also identified throughout the Commonwealth one-stop system as the Pennsylvania Career Link program supervisor. The key role of the state-level ES complaint system representative is the responsibility for the maintenance and operation of the ES complaint system. This individual ensures centralized procedures are established and practiced so complaints are processed appropriately. Additionally, the state-level ES complaint system representative is tasked with other responsibilities, all found within this part of the policy. The policy sections that follow detail some of the specific operational aspects of the ES complaint system that affect BWPO. Let's review policy elements that may more directly affect non-BWPO staff. This part of the policy explains how the ES complaint system interacts with the overarching local area one-stop complaint system policy and/or complaint policies deployed by other program partners. When non-ES-based complaints find their way to the ES complaint system representatives, they're trained to refer the complaint as quickly as possible to the appropriate entity. If a non-ES complaint is referred to a CSR, then the CSR will comply with the local area complaint policy, as long as it does not conflict with the ES complaint policy and guidance. It's always a good idea for the local area board and/or the operator to ensure all partners and service providers are made aware of the local area complaint policy and its associated practices. We'll get back to that in a bit. If there is no local area complaint policy, and there should be a local area policy, or the policy is not kept current, or if it has not been discussed lately, then issues may arise. The local area complaint policy must be understood by board staff, operator, program partners, service providers, and others. Should there be any reason why there is not a valid or clear local area complaint policy, the CSR will rely upon the ES Complaint System Policies Program List and BWPO's operational guide that lists certain program partners and service providers as being able to directly accept complaint referrals from the CSR. It's recommended the local board and operator review this policies program list. ES complaint system representatives may refer collected PA CareerLink partner program or service providers complaints not represented on the ES complaint system policies program list and present them to the PA CareerLink operator. It's recommended the local board and operator review the local area complaint policy, update that policy if need be, and provide the policy to all program partners and service providers so that improved service alignment can occur. At the end of the presentation, I'll talk more about the local area board requirements. This slide lists the programs found within the ES complaint system policy the CSR may directly refer complaints to in absence of a local area complaint policy. Note that all WIOA Title I program complaints are directed to the operator. Let's talk about state hearing officials and requesting a hearing or an appeal. This section of the policy was improved to better articulate one of the two previous U.S. DOL findings the State Workforce Agency had to address. Hearing requests can be made by an unsatisfied ES complainant or a business associated with ES discontinuance of services. The hearing request must be made in writing and contain the complainant or business signature within 20 working days of receiving a notification of the findings result. Once the request is properly verified by the state-level CSR, the state-level CSR contacts the Pennsylvania Department of State to arrange for a state hearing official to set up the hearing or the appeal, as the case may be. Our ES complaint system policy narrative clearly expresses the Commonwealth's process for requesting a state-level hearing and what happens when the Pennsylvania Department of State accepts BWPO's request for a hearing official. The rest of this policy section gets into operational aspects regarding hearings and appeals. The State Workforce Agency wants to ensure the complaint or discontinuance of ES service findings are resolved accordingly. That's a key reason why much of the ES complaint system policy narrative is based strictly on the relevant regulatory language. Let's move on to the next topic that US DOL clarified. discontinuance of ES services. The section of the ES complaint system policy that's raised many questions in the past regards the discontinuance of ES services. Not too long ago, USDOL presented a finding to L&I to improve this section of the policy and operational guidance, and we made sure not to miss a thing. Admittedly, this section's burdened with regulatory language and is a bit dense. However, the law and regulations must be followed, and we want all concerned to do exactly that. We need to point out that regulations provide a window of opportunity not to discontinue ES services. It's the responsibility of the ES program to make every effort to bring the violating business into compliance and prevent the discontinuation of ES services. Every chance is given to the employer to become compliant before discontinuance of ES services is initiated. Discontinuation of ES services should be considered the last resort. L&I staff will work with businesses to prevent a discontinuance of ES services. EF staff document actions taken to assist the business in this process and are made part of the case record. It needs to be said again, discontinuance of ES services is a last resort. However, there does come a point that L&I's hands become tied and a determination must take place. The final rule is definitive about discontinuance of ES services reporting, practices, and procedures. It starts with a list of 8 basis conditions that will cause a discontinuance of services. L&I may initiate procedures for discontinuation to businesses who do not comply with any of the 8 basis conditions found within regulations and are reflected within the policy. This presentation can't get into describing each of the conditions as our time's limited. When a basis condition is brought to the attention of the state level CSR, notification must be provided to the business deemed to have met one or more of the discontinuance basis conditions. The state workforce agency drafts a letter and is sent to the business that ES services are being discontinued. The letter does indicate how ES services may be reinstated. L&I may reinstate ES services after discontinuance of ES services occurred if 2 conditions are met. 1. The ES program is ordered to do so by a federal administrative law judge or an ETA regional administrator or a state hearing officer, or the employer provides adequate evidence that any policies, procedures, or conditions responsible for the previous discontinuation of services have been corrected and that the same or similar difficulties are not likely to occur in the future. And 2, the employer provides adequate evidence they have satisfied any findings, including to the complainant and the payment of any fines which were the basis of the discontinuation of service. We're almost finished, but I promise to revisit policy narrative local workforce development boards and one-stop operators will find interesting. And here we are, our presentation's last major subject. Local area boards must make sure the local area complaint policy and its associated procedures align with the ES complaint system policy and its operational guidance. I would recommend the local area policy be aligned with any other required program partners' unique complaint systems if they have such a policy. As part of notifying customers of the ES complaint system, all Pennsylvania ClearLink service sites must display the required ETA posters in a prominent location. If the posters become torn or worn, they must be replaced. Normally, the ES office manager will ensure this happens. The ES program staff record all Wagner-Peyser Act based complaints. To help the ES staff in this responsibility, the local workforce development board must ensure that any complaint that is associated with the Wagner-Peyser Act be directed to the local area's CSR. Lastly, local area boards must ensure all staff associated with the local area workforce development area, including staff to the board, operator staff, program partner, service provider staff are made aware of the local area's complaint policy as well as the ES complaint system policy and know how to direct and or refer customers' complaints within the workforce delivery area accordingly. All right, let's move on to some hyperlinks. So taking a look at the slide, I have two particular links set up for you. First, we'll take you to the general workforce development area of our L&I website. The second link will take you directly to the workforce system policy page. And when you look at the list of policies, you'll see employment service complaint system. Click on that and you will get to see the policy, the guidance, and the posters and everything else. Next, if you want more information about all things ES complaint system policy, feel free to submit your request or question to the resource account listed above in the slide. Of course, you can also contact BWPO state level CSR by reviewing the published policy for that individual's contact information. I recognize much of the policy is not something most people want to curl up in front of a fireplace and read. That said, when we serve our customers who may have a complaint or any kind of complaint, we lessen the pain and empower the person. Also, complaints sometimes reflect the quality of our workforce delivery system, allowing for one of WIOA's principles, continuous improvement, to be enacted. I want to thank all of you for being interested in the ES complaint system policy and to enjoy the rest of your day.